back in session post-lunch.
Thank you, Mr. President. Good afternoon to the Honourable Chamber. I rise in support of this bill, which seeks to repeal the existing legislation called the Proceeds of Crime. Now, before I commence my presentation, I want to first commend the Attorney General's office and his team for taking the time to have this legislation drafted and brought before this Parliament, because it's both timely, necessary, and most important, it is refreshing because it deals with war against crime in a pragmatic way. The existing legislation that we currently have before Barbados, as I highlighted, the Proceeds of Crime. Yeah, my mic is on. The existing legislation, the Proceeds of Crime, was enacted in 1990, so it is approximately 29 years old. It is an old piece of legislation. It focuses on two specific types of offenses: drug offenses and terrorism. Now, I believe Barbados is blessed because, and I knock on wood, we have not been faced with any serious instances of terrorism. And to my knowledge, I'm not aware of any person ever being charged as it relates to any type of terrorist offenses. The actual thorn that is in our side would more stem to drug offenses. Drug offenses were being committed prior to the enactment of the Proceeds of Crime Act and after its enactment. That is the issue that we currently face on a day-to-day basis in Barbados. So the issue with the existing legislation is that while it provides provisions for the law enforcement authorities to address proceeds of crime, its scope is limited only to drug offenses and terrorism offenses. If a country is serious about its war on crime, we have to first identify and recognize that in the last 29 years, crimes that may have been lucrative then, i.e. drug crime, has since then, based on criminals, there's been an increase in criminality by criminals. Now, their offenses more lucrative or just as lucrative. There's human trafficking, there's credit card scamming, there's identity theft, gun trade, pornography. There's a list of different offenses currently existing throughout the world and possibly in Barbados that are equally as lucrative. And those persons who ply their trade within those criminal activities do not fall under the existing legislation. So what does that mean? What is the consequence of that? I can amass a significant amount of wealth by plying my trade in all these areas and know that if I were convicted and I was smart enough to hide my assets, once I spent my time, I can come back into civilization and reap the benefits of my labor, my ill-gotten gains. That is the current parameters of the existing legislation, that once it's not drug offenses or terrorism, you're a free game. You're able to operate and do what you like, and the law can't touch you. I am of the view that this existing legislation is out of touch with the way in which we should address the sophistication of crime in the 21st century. When we look at the fact that in Barbados, you see criminals or quote-unquote persons, we perceive to be persons involved in criminal elements, living lavishly. We might not be able to identify the source of their income or how they are able to appear and live at this level of wealth. And over the last 20 years and 29 years, this has been a current occurrence within our society. There's been a re-emergence of persons appearing to be living lavishly with no one being able to point a finger to source of funds, source of income, how they have been able to amass this wealth. We tend to suggest that if it is not in the law, let bygones be bygones, he's free to do what he wants. I am here to say today that this bill before this honorable chamber today puts an end to that. This bill brings those persons into the scope. But the issue with the existing bill, the existing legislation, is that the only way it could enforce its powers is if a person was convicted of the offense for which they have committed. Conviction was the activator for the existing legislation. So no conviction, the act is not engaged. Now, we can all agree that the landscape has changed. We looked at the criminality, we can see over the 29 years, the way in which criminals operate is no longer the same. We don't necessarily have street-level criminals living lavishly. When you read the articles in the newspapers, there seems to be a common sentiment amongst persons that you would hear they interview inside of the village and communities. They would suggest that the young boy that wasn't accused of shooting in here, he doesn't have the means or the network to import a firearm. We don't manufacture firearms here. So somebody else is the source. But we, as Barbadians, we only see the end product. We only see where the crimes are committed. We don't see where the crimes began, the linkage. And the reason for that is because there exists what persons on the ground will call the link, the connect, the facilitator, this invisible hand, puppeteer, so to speak, that controls the underworld while not being directly involved in the underworld. Those persons it is extremely hard to link those type of persons to the actual offenses that we see being committed because they don't leave fingerprints. They don't touch anything. A phone call, a direction, and everything else falls into place. That is the most that some of them may do. But the person that we see being arrested and convicted, they do the legwork. Those are the ones that we actually see the law enforcement apprehending. So if we're serious about crime, on the one hand, yes, we are getting convictions and we are putting persons behind bars, but we are not dealing with the problem. We're dealing with the result after the fact. So in order to fight crime head-on in the 21st century Barbados, a bill like this is needed. This bill takes away any issues as it relates to conviction. But I will get to that later on in my presentation. Now, what we don't want in Barbados is a situation where we have persons who I just highlighted to you who can continue to commit various offenses outside the scope of the law. Because what it says is that these persons can continue to grow, become empowered, build their criminal organization, have a stronghold on communities, and wreak havoc in a society. And we as people of Barbados do not want that. We do not want to see Barbados, and we do not want to see individuals create a so-called garrison around them, where now they become invisible to law enforcement. This bill addresses those types of issues head-on. Now, I've just highlighted to you a number of deficiencies that exist under the existing legislation. Now, if we can acknowledge that the criminality and the landscape has changed, we can all agree that we need to approach it in a practical, modern, and fair way. It is my view that this current bill before this honorable chamber encapsulates all of those things. It is modern, it is practical, and it is fair. this current bill does not necessarily remove the existing legislation. While it might repeal it, it maintains some of the provisions within that existing legislation because it is still good law, and it was good law at the time. But now, having acknowledged that the criminal elements have become sophisticated, what this new legislation does is enhance the framework by expanding its scope, creating tentacles that are far-reaching. And while doing that, ensures that the process that any person is subjected to under the bill will remain fair and transparent. And as I said to you, this bill is quite extensive and it addresses a number of issues. But my presentation will specifically focus on its scope and the fairness of the process. Now, this bill primarily focuses on the recovery of proceeds and the instrumentalities of crime. Now, what does that mean? Proceeds of crime is self-explanatory in a way. It is basically any form or type of benefit that is obtained by an individual that was derived from some form of criminal or unlawful conduct. And that benefit is considered to be an ill-gotten benefit. Therefore, that would be considered proceeds of crime. And what is the instrumentality? The bill defines the instrumentality as any property used in or in connection with or intended to be used in or in connection with the commission of an offense. So it's a lot of jargon that I just gave to you. So let me just break it down. Any type of property that you use either in the commission of an offense or is related or connected to an offense will fall under a category of instrumentality. So to put it into perspective, if someone goes and commits a robbery and they use the vehicle in the commission of that robbery, the vehicle would be considered an instrumentality of the crime. And as some of you may be aware, there are heap piles of boats, vehicles, boats, cars, all types of property are currently in the compound within our law enforcement agencies, all having been confiscated under the proceeds of crime for drug offenses. But now this bill is taking a step further. It's saying to you, well, if you're into robbing, if you're into burglarizing homes, if you're into human trafficking, whatever instrumentality that you use, we can also confiscate because it falls into the scope of the legislation. Now, the bill is split into two sections. There's a criminal process and there is a civil process. In the criminal process, it focuses on the recovery and proceeds and instrumentalities of crimes under that criminal process. And the civil process looks at the recovery through the civil process. So if I can turn my attention now to the criminal process, in respect of the recovery under this process, the court will have the power under Section 13 of the bill. Under Section 13 of the bill states that where a defendant is convicted by the court of an offense or committed to the court by a magistrate, is essentially committal proceedings where a magistrate now commits a person to high court to deal with this confiscation order or forfeiture order, the court now has the power to confiscate any benefit that the defendant obtained as a result of an offense, unlawful offense, forfeit the property that is the instrumentality of the offense, or forfeit property that was obtained as a result of the commission of the offense. This bill gives the court the power to do such things. However, even though this bill gives the court certain powers, there must still be due process. Because as I said, this bill is fair and transparent. So it is not a situation where the court is going to say, you committed an offense, this is the process of crime, this is the instrumentality of an offense, we can take up everything. No, there must be a process. And as we're dealing with this under the criminal process, we're operating on the premise that the person has been convicted already. So now they're looking at confiscating or forfeiting the particular instrumentality or asset that was used in the commission of the offense. Under this bill, the provisions of this bill have implemented a procedural process that must be followed. The prosecutor must give the defendant 14 days written notice of the application for a confiscation or forfeiture order. And the defendant or any person who has an interest in the property may appear before the court and give evidence. So what this means is, if you may not necessarily have been the person who was arrested and convicted for an offense, but jointly have an interest in the property that was used in the commission of the offense or that was obtained through the commission of the offense, you as the individual, even though you're not within the criminal scope for conviction, you also have the right to be heard. So the bill grants persons the opportunity to come and give their side of the story, to try to explain to the court why the particular property or asset should not be taken up. They have the opportunity to do so. So this is not a situation where this bill is operating and just taking up people's things without any address to due process. Now, there's a limit, as it relates to forfeiture orders specifically, there's a limit. There's a 12-month limit. 12 months after the day that a person has been taken to be considered to be convicted, the prosecutor has 12 months from that day to make an application for forfeiture based on the bill. After that period, the prosecution would not be able to make an application for forfeiture. And that is something that should be noted, that the law enforcement agencies have to operate swiftly. They can't sit down on the laurels and wait to 10 years later and decide, oh, he getting out now, let me go after something and kick him further down the road. It does not operate like that because we are operating above board and we are being fair under the instrument of due process. And if that was not enough, under section 43, clause 43, subset 4 of the bill, the court has additional things that it must consider before determining if to grant a confiscation order or a forfeiture order. Under section 47, subset 4, it states that the court must have regard to the rights and interests, if any, of third parties, as I highlighted earlier, the gravity of the offense concerned, any hardship that may reasonably be expected to be caused to any person by the operation of the order, and the use that this order of the property or the use to which the property was intended to be put. These are all provisions that the court has to consider before an order can be granted. These are all safeguards. It is to ensure that proper due process is taken, that all sides of the story is heard, that persons have ample time to make their representations before any decision is made as it relates to forfeiting or confiscating property. Now, once that process is completed and an order is made and the court determines that an item should be forfeited or confiscated, the safeguards don't stop there. The bill has made provisions for appeal. So, as we already understand, we're operating the criminal process on the premise that a person has been convicted. So if a person appeals their conviction, and on appeal, that conviction is squashed, but there was an existing forfeiture order, confiscation order against them, there is provisions within this bill for that order to be set aside. And not only will that order be set aside, if there was inherent damage to a business or there was some form of harm to the individual as it relates to those orders, there are provisions for compensation within the existing bill. So the blow that you may suffer once vindicated at the Court of Appeal, you will now be compensated accordingly. Now, there's one particular thing within this bill that must be highlighted and ventilated, and that is the standard of proof. Because most persons listening to watching criminal movies, reading the newspapers, by now know that within the criminal process, the standard of proof is beyond reasonable doubt. Now, to put it in layman terms, essentially, the court must have a significantly clear thought within its mind. The court must be reasonably sure that the person who committed the offense did it. But under this bill, as it relates to the orders under this bill, you are not subjected to the standard at the criminal level. The standard of proof is lower, much lower. It is the standard of the civil court, which is on the balance of probabilities. So what that means is, if someone comes to you and asks you to explain how you end up with so and so and so and so, and how you drive this and how you own that, all you have to establish in the court is that it is more than likely possible that you obtain it by legitimate means. You don't have to make an inundated amount of evidence before a court to establish beyond a reasonable doubt that you're absolutely sure that I obtained this legitimately. You just have to explain enough that a person is more than likely of the view that it was obtained through legitimate means. That is the threshold, a very low one. So I just wanted to highlight that because I don't want persons to feel as though, having established all of these safeguards, the criminal standard for proof is high, that a person now feels that this bill is to their detriment, that they cannot escape, or escape is not even the best word to use, that they cannot address any issues as it relates to property that they own if they ever came under the scope of this bill. Now, these features that I have highlighted all illustrate that this bill, the process that is under the criminal process, is transparent and fair within its application. So I will now address the other aspect, which is the civil process. Now, Section 69, Clause 69 of this bill establishes a recovery authority that has the power to recover property obtained through unlawful conduct and property that was used in or in connection with unlawful conduct. And that power is available to the Revenue Authority regardless of whether or not you have been convicted of an offense. Not interested in conviction. This is the civil process now. The criminal process dealt with you being convicted. Civil process does not. The civil process now has expanded the scope, whereby now the recovery authority is able to follow the money. We are following the money trail. That is what the recovery authority is doing. Once they can identify the original property, and can determine that that original property was obtained through unlawful conduct. If the property was disposed, sold to someone else, mixed with legitimate property, however way a person tries to cover their tracks, because the source, the genesis, was through unlawful conduct, this bill has the scope and the tentacles to reach them. You can no longer hide and try to wash your money 10 or 15 ways, because if the source can be identified, it will be traced. And wherever it leads, the person at the end, the property at the end, has to show its hands, has to indicate how you have acquired it. Now, I know some person might be a little concerned by what I've just did, because it may be perceived as though if you buy something from somebody, then that you may very well be subjected to this legislation and you run the risk of losing your property. The bill makes provision for instances like that as well. The key and operative words here that I will use now will determine whether or not a person will be protected under this legislation. If a person purchases or obtains an item that its genesis could be traced back to unlawful conduct, but this person themselves operated in a bona fide way, they operated in good faith, and they are not linked or connected or could be traced to a person as benefiting from the same unlawful trade, then they would be protected under the legislation. I think the clause is can I find the clause anymore? Can't put my finger on it. Make it count. Yeah. 74. Thanks. No,
Yeah, there it is.
section 74. No, under section 74, where property obtained through unlawful conduct or tainted property is or has been recoverable property, the property which represents the original property is also recoverable. That is what this bill highlights. So it don't matter. Once the property is linked to unlawful conduct, no matter how far it goes. And the provisions in this act also stipulate that even if the property goes outside of our borders, it is not out of the reach of the bill. This is a piece of legislation that will change the landscape on which criminals operate. No longer will persons who benefit and receive ill-gotten gains within the criminal world be able to flaunt it without consequence. This bill is gender neutral and class neutral. It does not care if you're from the heights or from lower echelons of society. It does not matter. It has the provisions there for the authorities to go after anyone. Now, there's this fear that provisions in this bill will enable the authority to harass people and go after the quote-unquote block boys and the normal street-level persons that we normally see on a day-to-day basis. But that's not the intent of this bill. Because law enforcement shows that those persons are usually dealt with through the criminal process. So this bill does not necessarily target them. This bill is not going to be used as a harassment tool. This bill is going to be used to enhance our fight against sophisticated crime. The fingerprintless crime. This bill will be intelligence-driven. Law enforcement already know the persons that are out there that are benefiting from all of these criminal activities. But there's no provisions, there's no legislation in place that can empower them to go after them in a way that is meaningful. This bill now strengthens our fight against crime. Now, a bill such as this is profound, because while I might have just explained to you the fairness of the process and the scope of the bill, I have not really gone into the actual benefits that we would reap from a bill of this nature. Because when this bill is legislated and is enforced, this bill will now have the power to remove assets from criminals individually and at an organizational level. So we are breaking down the structures of organized crime in Barbados. It reduces the working capital that a man who decides he can take his first chance, his first risk at doing some form of big crime in hopes that he's going to reap some big benefit. I said, one chance, if I succeed, I'm done with that. Whatever I earn from this here, I can live with the rest of my life. Even he who only commit the offense once, reaping a big, large sum, even he will fall under the score. Because it don't matter how much time they do the crime. Once you're benefiting from it, and it's from unlawful gains, unlawful conduct, the provisions is there to go after those persons. It will curtail the growth of the criminal activity, because once we can disrupt the facilitators, the invisible hands, it means that we break that link between the supplier, the connect, the facilitator, and the street-level person. This will create a major blow in the disruption of the organized crime, and in turn, prevent individuals from becoming entrenched within communities, so that instances like what Senator Springer said when he heard the young boy indicate he wanted to be a drug lord. Slowly but surely, this type of legislation will be able to pull back a number of persons who may have that ideology, because they would now see that individuals who had lived high, it was short-lived. Because no, today they have something, tomorrow they have nothing. Because crime does not pay. And that is what is at the core of this bill. This bill is saying to Barbadians, crime does not pay. You can get all of the burden, but we will not let you get any of the benefit. That is what this bill is about. It is a foot that is placed strongly on the neck of the criminal world. If we can't convict you through the criminal courts, we can certainly follow the money that you received through the ill-gotten gains, and we can cripple you under this bill. This is a profound piece of bill, and I hope that once this is legislated, that the authorities be able to take the necessary steps, implement it to the core, which is to be fair, transparent, and hopefully we can see the war against crime prevail and a significant reduction in organized crime in Barbados. And with those few words, Mr. President, I'm obliged.
I next recognize Senator Holder. The floor is yours.
Thank you very much, Mr. President. I wish to offer a short contribution. I promise I will not be as long as the previous speaker. I know that the attorneys in the chamber will go into great detail on key aspects of this piece of legislation. the merits, demerits, etc., from a legal perspective, but I wish, Mr. President, to make my short intervention on a different angle. I am particularly pleased this afternoon. I woke up this morning, Mr. President, and I felt that it was a good day. I am pleased for two key reasons. You see, I got the opportunity, Mr. President, to go on my treadmill this morning for about 30 minutes, and that helped. I am of the view with the heart rate, you see? When you get to this age, Mr. President, these things become necessary, a part of your daily routine. So from a personal perspective, I felt really good having done that. And then the second reason, Mr. President, has to do with the piece of legislation we're debating now. The fact that we are able to bring this bill to the chamber and when passed, have this in our legislative apparatus, I feel, Mr. President, is a good thing. As Senator Boyce would say, this is good law. This is good law. And Mr. President, for two key reasons which I wish to highlight this afternoon. I want to focus, first of all, on the issue of what I call self-governance. And the question must be asked, why would an administration seek to regulate itself in such a stringent manner as this bill purports? I think it speaks to the philosophy of this administration, and I know that Reverend Rogers would appreciate this point. It speaks to the core values. It speaks to the covenant that this administration, party as it was at the time, would have entered with the people of this country. I think it, again, underscores who we are as an administration. This is self-governance. And speaking, Mr. President, to the Deputy President at lunch, and I like to refer to him a lot, as I see him as a very seasoned person in public life, understands a lot. I'm not going to disagree with him there, Chair. But in speaking to him, you know, he recalled an example of someone saying to him, well, why are we bringing these pieces of legislation that seemingly would cause us to shoot ourselves in the foot? And I reflected on that comment over lunch. And I'm satisfied, Mr. President, that it goes to that philosophy that we hold to as an institution, one of transparency, one of accountability, one that says we are going to be upfront with those whom we govern, and we are going to always seek to act in their interests. And I think, Mr. President, that ought to be lauded. That's the truth. I do. I think that this is good for an administration, and I took comfort as well from the fact that the leader of opposition business in the Senate agreed wholeheartedly with this bill. And well, I won't say I won't agree with that that comment on the side. But I took comfort from the fact that we did not have any opposition from the opposition on this matter, because we all, I believe, in this chamber will agree that this is good governance. This is good governance. And I go further to strengthen that point. And I made gave the quote some time ago from Mother Teresa that is worthy of repetition, where she said that honesty and transparency make you vulnerable, but be honest and transparent anyway. Be honest and transparent anyway. Here it is that we are bringing a piece of legislation that is retroactive 20 years. The leader of government business this morning reminded us of the administration that was in power 20 years ago. This legislation is retroactive 20 years. Now, if that is not being open, there's no gun to our heads that says that we needed to introduce that particular time horizon. But we wanted to ensure, Mr. President, that we didn't limit it to 1 decade. You know, we wanted to ensure, because we know that persons out there will talk. We wanted to ensure, no, we didn't limit it to 1 decade. The time horizon proposed is actually 20 years. And we're saying that, look, we are prepared upon proclamation to even go back then. Let that be the time horizon for this bill. For this bill. Mr. President, I may need some protection from the chair, from Senator Tate in particular. Senator Tate in particular, who feels that it should have been the last decade only. But we needed to go a little further than that. All right. So why, Chair, I want to draw our attention to a section in this bill, Part 4, Division 2, that refers to unexplained wealth orders. And I read this yesterday. It's a long bill. It's close to 200 pages. But I thought that this was worthy of review, because it makes reference to, at Section 136(1)(3).
Thank you.
It said the requirements referred to in Section 135(1) are that, and I quote, Mr. President, the known sources of the respondents' lawfully obtained income would have been insufficient for the purposes of enabling the respondent to obtain whatever property they have. And at B, it goes on to say the respondent is a politically exposed person. Now, we're reminded that all of us who sit in this chamber qualify. This is now the nomenclature that we actually will be known by. We are politically exposed. And therefore, I think that this should give some comfort to our citizens to appreciate and understand that we, through the passage of this bill, we will hold all those who are considered PEPs accountable, responsible even for explaining how they arrived at unexplained wealth. Mr. President, now, honestly, I mean, this is such a profound step, I think, for us as a country. How did they arrive at this unexplained wealth? The leader of opposition business agrees, as I do, that all those who, past, present, and in the future, who come to public life and amass significant portions of wealth, Mr. President, that they are unable to justifiably explain so from the means that they have, need, Mr. President, to face some sort of court of law. That's the truth. I agree with the leader of government business, of opposition business on this one. They need to be carried before the appropriate judge to be able to give an explanation for this. Because we all know the salaries of cabinet ministers, of senators, of parliamentarians, by extension, the stipend for senators. But the point is that whatever is received is known by the public. So how is it, Mr. President, that you, having received this amount, and you knowingly received this amount, can, in a matter of 5 years or 10, amass such assets without justifiably giving an explanation, Mr. President, I think is worthy of some sort of review. I agree with that. I agree with that. And therefore, this piece of legislation is intended to address that. But it goes further. It goes further, Mr. President, in Section 4, on page 155, where it goes on to define what a politically exposed person is. And it says that Section B, a family member of a person referred to in the earlier paragraph. So a family member, Mr. President, when I saw that, I said, wow, that means mothers are included. That means siblings are included. I heard the leader of opposition business in the Senate talk this morning about this, using the analogy, and I quite agree. I quite agree. Family members are also included, but then go there. It is up there, sorry. At section C, it says a person known to be a close associate of a person referred to above. That means pals. Pals are included in this definition. Close associates. Pen pals? This is not a joking matter. I am trying to keep a straight face here, chair listening to all their sides. But this is not a laughing matter. This is a very serious issue in this piece of legislation. We're saying that it goes beyond those who come to public life only and serve in this vein, but it also includes their family members. It includes their close associates, and it goes back 20 years. It is retroactive for that period. This, Mr. President, is a significant piece of legislation that, in my view, binds this current administration as well. Why? I said it before, it's worthy of repetition. This administration was the one in power 20 years ago. And what this says to me as a takeaway is that all of us, on the passage of this, if we have not yet committed ourselves to that which I believe we have, all of us need to pay close attention going forward to how we do business. In other words, in a very simple way, we need to ensure that we operate above board. We operate above board. Yes, I agree that it is not hard, and I'm sure that all of us are committed to it, but it is worthy of repetition. We need to operate above board. You see, I think it was Lord Acton that said, power tends to corrupt, and absolute power corrupts absolutely. Mr. President, I don't agree with that statement. I do not agree. Do not agree. I tend to go more so with Abraham Lincoln's point when he said, if you want to test a man's character, give him power. That is what Lincoln said. So I hold to the view that all that the power will do will manifest who you are innately. It will demonstrate who you are as an individual. And so when we come to public life, we have a responsibility, I believe, to hold to certain moral and ethical behaviors. And if we are not that way, we need to become that way. We need to become that way, because I don't believe that you should necessarily legislate morals. You shouldn't have to. But there comes a time that, yes, you have to ensure through the legislative process that you're able to influence the kind of behaviors that are needed within the society. But it gives me comfort this afternoon, Mr. President, as I conclude this first point, that this is a step in the right direction. It speaks to self-governance. It speaks to our ability as an administration to be upfront, open, and transparent with those whom we govern, and we're doing so by showing them that we are also prepared to be held to the highest level of scrutiny in the governance of the state. I think that is good. We've demonstrated this already with the declaration of assets, all members of the executive. We've done this with the integrity in public life bill that is to come. We've done this with the public finance management bill and several other pieces of legislation, all in the same direction, demonstrating that, Mr. President. And then the second point I want to hastily get to is that we need to understand that we are operating in an international environment that places some strict demands on us. I hear the commentary sometimes coming from people in the press, social media and all that, and it is very easy when you're out there, Mr. President, to pontificate and speculate on issues. But the fact remains, too, is that Barbados is not unique in this vein. We operate in an international environment where we do not set the rules. We do not set the rules. And we heard already that our leader mentioned that, yes, Barbados has to become compliant. We have to become compliant with the Financial Action Task Force. There is a Caribbean Financial Action Task Force that we are a member of, and I am privy, Mr. President, to receive this document today, Anti-Money Laundering and Counterterrorism Financing Measures, February 2018, which speaks to a review that was done on Barbados, and ironically enough, back in December of 2016. Sorry? Yes, it'll be made a document in the House. Right. So here it is that in 2016 of December, Mr. President, a team visited Barbados to conduct an audit. And this document speaks to their findings. Ironically enough, the document speaks to the fact that relative to politically exposed persons that we were not compliant. We were not compliant with the regulation. But nonetheless, here it is, this document is speaking to a number of key findings, and it makes several recommendations, some of which I am pleased, Mr. President, have been captured in this piece of legislation. But what I want to note in this chamber is that since December 2016, when this audit was done and information shared with the administration at the time, there was every opportunity back then, Mr. President, to do something about this legislation, to bring to bear in the parliament of this land the appropriate legislation that would make us as a jurisdiction compliant. That was not done. That was not done. And so what we have is a situation where, following the May general election, when this administration came to office, that we now have to be tasked with trying to bring all of the necessary pieces of the legislation to this parliament that they can be passed, that this country can be compliant with international regulation. I think, Mr. President, that is a point that is often, it would seem, missed on those that would aspire to public life, those that would aspire to office in this country. Often missed, because when you hear them speak, you wonder, were you not the administration up until May 23rd last year? Were you not aware of several of these audits and several of these requirements? What did you do about it? We know, for example, that last December, that this chamber spent, I think, close to midnight on 2 occasions seeking to pass several pieces of legislation because a former minister of international business had made certain decisions relative to the international business sector, and we therefore had to scurrily put the legislative arrangements in place that we would become compliant and therefore not blacklisted. Scurrily had to do so. And I really commend the members in this chamber. I was off island at the time, so I couldn't join you. But the point is that we had to meet as a chamber to address those issues because, Mr. President, an administration left office without doing so. And so here we are again, because of the requirements of the Financial Action Task Force, seeking again to make Barbados compliant. And this, it would appear, Mr. President, has been the modus operandi for this administration, where we have to try to get Barbados compliant, meeting the regulatory requirements. And the thing about it is that we understand we're operating now in a changing international environment where so often the goalpost is changing as you try to comply with one rule. As soon as that is done, Mr. President, we hear of another. As soon as that is done, Mr. President, another. So the post is constantly being shifted. And we as small island states have little or no control really over that. And so we are tasked with just seeking to become compliant. And this is what has happened. Not only the FATC, but we know of the GDPR. The General Data Protection Regulation passed May 25th last year within the EU. The anti-money laundering regulations now put so much on us that we have to comply with. And each time, Mr. President, this calls for improvements in your legislation and or, if not improvements with the existing ones, the introduction of new pieces of legislation. So the game, as it were, is not defined or determined by us. The rules are not determined by us, but we have to comply. We have to comply. We have to comply. And so I commend this as required reading, Mr. President, for all members of this chamber, so we have a better appreciation why this piece of legislation now is before us. Barbados has to comply. The Anti-Money Laundering and Counter-Terrorist Financing Measures Report. It is the Mutual Evaluation Report, February 2018, Mr. President. It is required reading for every parliamentarian, I believe, and anyone of interest to have an appreciation for what this committee would have found based on the audit, based on the evaluation of Barbados, and what the recommendations are, so that we can put this within context. And
Find it.
yes, but I know that my colleague is going to do so in her presentation, so I'm trying not to preempt what she will say. As my focus this afternoon, in the short time that I said I was going to speak, Mr. President, is to really underscore, one, the commitment to self-regulation, self-governance on the part of this administration, and two, to let us understand and appreciate that a lot of this also is happening within the context of a changing international business climate and environment. I think that needs to be underscored, because my good colleague, when he rose this morning, I think it was, begun with the usual rhetoric about legislation being rushed and the process being rushed and so on. And I didn't rise to interject, because I like for him to flow. But the fact is that on March 1st, if he had reviewed his notes, on March 1st, this legislation was sent out to all members in this chamber on March 1st. I believe today is the 13th? Right. So that's 12 days ago. So 12 days ago, on March 1st, this piece of legislation was sent out, and I think, therefore, it gave us, in that time, some 12 days to review.
Point of order, Mr. Chairman. She is misrepresenting.
Who is she?
Senator Holder is misrepresenting what I said. I was speaking to send it out to the country. It should be circulated as a bill by the government printery, and it goes to, and it's circulated in the official gazette. Not only us, we are not all knowing. The other people in the country should, we have a lot of the bar associations, everybody should be on board with this bill. That's what I was talking about. I don't want to be misquoted or misunderstood.
Please continue.
Thank you, Mr. President. I said that I tried not to interrupt him, but clearly he sought to interrupt me. With the member the senator sought to interrupt Mr. President, and the fact is, at the beginning of his presentation, the point was made by the senator that he only got the opportunity to read it within the last day or two. So it was from that perspective, Mr. President, that I spoke, that though he elected to read it within the last day or two, is not an indictment on the process, because it was sent out since March 1st. And therefore, if, you know, he wanted to, he had 12 days that he could have read it. But the point, Mr. President, is that we have, at times, it would appear, to hastily get these things done because of the reality that we are not in this world on our own. We operate within a global environment, a global economy, that we do not set the rules. We do not set the rules. Many of the large international organizations, following on chair from the Bretton Woods institutions, they're the ones who set the rules. And so we oftentimes have to be compliant. That is the point. And I would beg this chamber to have an appreciation for that fact as well. So when pieces of legislation come before us, especially of a nature like this one, that we understand that beyond the fact that, yes, we're committed to governing ourselves well and being transparent and so on, that in addition to that fact, we also need to meet certain international requirements and regulations. So, Mr. President, I wish to lend my support to the bill before us. I know it's a lengthy bill, and I believe that it is, again, another piece of legislation that's in the right direction for us as a country. And so, therefore, Mr. President, I offer my wholehearted support this afternoon. I'm obliged to you.
Senator Greenwich.
Thank you very much, Mr. President. Mr. President, as a young boy, I was taught by my Sunday school teacher, not 8 years ago, sir. I was taught by my Sunday school teacher that if I follow the 10 Commandments, that there would be a place for me in heaven. And then as a lawyer, that's what she taught me. As a lawyer, I was told that there are really and truly 3 precepts to the broad rules of law. That you should live honestly, that you should injure no one, and that you should give everyone his due. And that if you live according to those precepts, you should have no problems in life. Mr. President, this particular piece of legislation is that one that encourages us to live honestly. And do not think for one moment, sir, that this is something that applies to the drug dealers alone. It applies to all of us, that we should live honestly. And we have heard from time to time, sir, and we did hear it again this afternoon, that honesty and morality cannot be legislated. But man's behavior can be regulated according to the law. And that is precisely what we are trying to do with this piece of legislation. We are trying hard to regulate man's behavior. Of course, Mr. President, you and I know that this particular piece of legislation is not going to be popular with the criminal element in our society. This perhaps is the last thing that they want to see or to hear about. The fact of the matter, though, is that we cannot allow that criminal element among us to dictate and to rule this country, Barbados, that we love so much. And so, sir, this legislation sends a very, very strong message to criminals that they should not, and as long as we are around, they are not going to benefit financially from the crimes that they commit. Mr. President, I call this extremely bold legislation. Very, very bold legislation. Sir, it is legislation like this that tells Barbados you have an Attorney General. I admire the work of the present Attorney General and those officers in his office. I admire them. When the Attorney General speaks today, he speaks like someone who knows what he's talking about. I used to know of another Attorney General that mumbled and fumbled, and you could hardly understand anything that he was saying. But since becoming Attorney General, this particular Attorney General that we have, he has never taken his eyes off the road. Every single thing that has come from his office so far has been good and of a very high standard. Mr. President, yes, we already had bits of legislation that dealt peripherally with certain things in this bill. We had a Proceeds of Crime Act. We had a Drug Abuse Control Act. But, sir, these acts did not adequately anticipate the movement of property or the level of sophistication of today's criminal. This act does it, and does it thoroughly. This, sir, I consider to be a new piece of legislation in which we are taking that quantum leap in the fight against illegal drugs in a way that has never been done before in Barbados. We had known of this problem, sir, years ago, for many years. And we had never gone this far to address the problem. We saw people driving the biggest cars and living in the biggest mansions. And it was known to many in society how they acquired such property. Mr. President, by and large, sir, those assets are status symbols. And those status symbols, sir, and those assets will attract and entice many among us. But I take this opportunity now to caution those persons not to go into any commingling and joint ventures with certain people, and they know the people I'm speaking about. I caution them, sir, not to accept gifts of money and property from certain people, and they know who I'm talking about. We have, sir, if you look at Section 9 and Section 74, the whole question of what they refer to as tainted gifts. Because if that gift is traceable to the proceeds of crime, you can, yeah, under Section 74, you can lose that. It's under Section 9 as well as it's mentioned. Mr. President, a few years ago, I was in Miami with a friend of mine. And sir, my purpose there was to buy a vehicle. We had gone to about 2 or 3 dealers, and I hadn't seen one that I liked. And so we were told by a gentleman at Toyota, he said, well, go to this place. And he gave us a little card, and we went there. And he said, you're sure to get a good one, and it might not even be as costly as one here at Toyota headquarters. And I did not even know what the place was all about. When I got there, I was surprised to see the type of vehicles. I was looking for Toyota Camry. I saw one Toyota Camry in that place. I saw the Lexus. I saw the Mercedes. Honestly, I didn't check to see if they were Lamborghinis or what the name, but they were like those racing car type vehicles. I saw a Porsche. And we were told that this is where they auction off cars and so on. They had Kawasaki motorcycles and so on too. And they said this is where they auction off these vehicles, which indeed I know they're the proceeds of crime. And I mean, they were the most expensive and most beautiful vehicles imaginable. Strangely enough, though, there was no auction on that particular day because the auctioneer, I think we got there about 11 o'clock and he was not going to be coming till 3, something like that. Anyhow, the point is that we spoke to 2 gentlemen who were there. And they explained to us that they come there quite often and they purchase those vehicles fairly reasonably, and then they turn around and they sell those vehicles to make a profit. It was the first time for a long time that I had a little pang of conscience. Something spoke to me almost in the way it would speak to Senator Holder and Reverend Rogers, and said to me that if you purchase a vehicle and from this particular establishment, and then you sell it again to make a profit, that indeed and in fact, you too might be benefiting from the proceeds of crime. Honestly, that came over me then, and I'm living it today as I lived it then. I believe, sir, that the people who bought those vehicles that day and went and sold to make a profit were indeed benefiting themselves from the proceeds of crime. It was a dilemma that came over me perhaps in a way. Anyhow, Mr. President, these big vehicles and the big rigs, as you will call them, yeah, having the beautiful women and so on, you know, you get various and varying reactions from them. No, this is a fact. I mean, you know, and everybody knows what I mean. But I'm not going to explain it any better because I know. But it encourages certain onlookers, Mr. President. It encourages certain onlookers to say, I want to be like that. And that is the point I'm getting to. It encourages certain onlookers to say, I want to own those things too. And therefore, it acts as an encouragement for some people to get into that same ring. Because, sir, we can turn up our noses as much as we can. The stench of ill-gotten gains is still pleasant to some people in Barbados. It's a fact.
Good one. Yes.
Oh, but I never knew that I could rock so poetic.
The stench. You will spend about 10 minutes on that in 2 weeks' time.
The truth of the matter, sir, is that the reaction of some people could be completely different. And some people could easily say, he has to be involved in something to get those things because, sir, huh? No, I'm not.
You use that in 25th.
The point I want to make, though, Mr. President, though, is that this legislation should really and truly act not as an encouragement, but as I think it was Senator Sands and Senator Springer said, that it should act as a deterrent to the criminal element in society, not as an encouragement at all. Where I'm concerned, Mr. President, this legislation emphasizes the fairness of punishment. It makes sure, sir, that the punishment fits the crime. It says that we should shun those ill-gotten gains and that is not a vice. It's not a vice, it is a crime. And actually, it is a crime on top of a crime. And that will come after you for both the crime and for the ill-gotten gains. Because it is a way of saying, too, that incarceration by itself is not the punishment for unjust enrichment. Because when you get your 5 years and you go and you come out of jail, when you are released afterwards, that Lamborghini or that Mustang or the 3-story mansion, they're still there and they're still yours. And there are some individuals who would look at you to your face and tell you, I do the crime, and I will pay the time. Meaning, of course, that when they come back out, they still land on both feet. Now, Mr. President, it is clear to all of us in this chamber that confiscation of property is a very serious matter. And by going through this particular bill, we realize that the bill is saying that confiscation and sale of property and so on must be done in accordance with the law. And what we are seeking to do under this legislation is ensuring that it is done correctly. And the bill, maybe the reason for the length of the bill too, is trying to make sure that we leave no stone unturned. If you look, for instance, at the entire section, I think it's Division 2, sections 14 to 42, that entire piece of legislation, that section deals with confiscation. So, sir, this is signature legislation, and it is clear that without this piece of legislation too, and the way it is done, that lawyers could successfully, or would have been able to successfully challenge many attempts to confiscate and to sell an individual's property. So we have to make sure that we are on very, very safe ground. I think it was Senator Sands who was speaking on the whole question of conviction, confiscation. And it is to be noted that confiscation is not to be based on just a mere suspicion. You can't simply confiscate someone's property because you suspect, and so on. The actual confiscation, that is going to occur only after the individual has been convicted. It must be established too that the property that you are confiscating was obtained from the proceeds of crime. So there should be no loopholes in the law, and you have to make sure that you get it right. So if a person is to be acquitted under this piece of legislation, let that person be acquitted under the legislation because the person is innocent outright, and not because there is a means of escape because of an escape somewhere in the act. You know, the whole question of people getting away from the law because there is some little escape clause somewhere in the legislation, and sometimes it hurts you to know that the person did the crime, but because there was some little thing. I remember, for instance, there was a classic case at Borden Hall Court years ago where someone had stolen a calf, and the case didn't come up until it was kept there at Borden Hall as an exhibit. It didn't come up about 3 years afterwards. And when they produced the exhibit the morning in the case, the fellow said, I didn't steal that. I steal a calf, this is a cow. So I sometimes you get away with a loophole in the legislation. Huh? No, that's a fact. That is a fact. It's a fact. It's a fact. The case. Remember too, Mr. President, that very often the culprit is always ahead, a little step ahead of the legislation. And there are what I consider to be a lot of gyrations of ownership and gyrations of the ownership of these assets. Sometimes the property that you're going after, you find that could be in as many as 4 names. One property, but 4 people are there as the owner. Sometimes the person owns 4 separate properties in 4 different names. Sometimes the property is in the name of the children. The property is in the name of the spouse. The property is in the name of the company, and so on. Property is in the name of... But the point is that the actual criminal, he does or she does everything to make the connection of the assets as difficult as possible. Not him, it's somebody else. The point I'm making is that once the property, however, can be traced to the actual crime or to the proceeds derived from the crime, it can be confiscated. And you'll be made to forfeit what you've acquired from the crime. Here's the rule is accepted. Yeah. Under, I think, clause 103, the arm of the law can stretch far and wide. Even if the property is outside of Barbados, even if that account is overseas, once the connection is made between the assets, the account, and the property, and the case is connected to Barbados, a Barbadian court can reach out and actually touch that property. It is in the scope of the powers of the court. That's a fact. And as quite a few people have remarked already, sir, there is a 20-year limitation. So the law can look back as far as what you were doing with that property 20 years previously. Senator Holder and Senator Walker this morning have both elaborated on that point. And sir, section 136, that seeks to explain to us, it speaks to unexplained assets. I call it unexplainable assets, because I think it's more readily understood if you see it as unexplainable. You can't explain how you came by it. Yeah, I got from this particular section, sir. The unexplainable. Who was this morning? Yes, this morning when Senator Walker was speaking, and he was actually making the point that there is what is the standard case, the test case in England for unexplained assets. And he was speaking about this $1 million ring. And indeed, Mr. President turned to me and said, you should have bought a ring from Woolworth. Because the main reason why this particular man had to explain or couldn't explain the link between his means and this ring was because that ring was too expensive. If he'd bought one from Woolworth, perhaps he would not have been able to track him down. That's right. But that particular section, sir, it requires that an individual who is being investigated should be able to explain, for example, how come on a meager salary of $2,000 a month, you are able to obtain these 3 cars, a yacht, and 2 mansions. Because the lavish lifestyle that you're living now, that is what is actually working against you. I too agree that it is a pity that we who consider ourselves politicians, that we are now scrutinized and perhaps suspected in a way that politicians were not before. When you go to the bank nowadays, as Senator Springer was explaining, you have difficulty in getting past the bank and even in opening an account these days. That is tough. It's hard. Very, very hard. And there was a time, though, I'll be honest with you, there was a time when I would have defended politicians. I would have defended every one of them. But in recent times, I am defending none of them. We can no longer say that politicians are not susceptible to bribes. We can no longer say, once upon a time, I believe we could have held our heads high and say, not he, not he, not he. We have to admit that the face of crime in this country has changed. And the face of the criminal is a face like politicians' face. True. We can no longer say not. If we came into politics poor and couldn't pay the rent and so on, and then suddenly we have bought a property, one in Millennium Heights and one in Royal Westmoreland, and then we have sorry, sir. I didn't mean that, sir. No. I withdraw that. I withdraw that. We have bought 2 properties wherever they are. We have bought these 2 properties, sir. only as an illustration, sir. Yeah, and you have to be able to explain how you got the yacht and so on. And if as a politician you can't, I have no problem in you being investigated from top to bottom. A lot of them open sports bars and so on, all types of things. Lots of. Mr. In St. Philip too? In St. Philip. Mr. President, sir, if under Section 53 and Section 54, I think those are the sections, if the prosecutor suspects that the culprit will dispose of the asset, the prosecutor can apply to the court for a restraining order, which would prohibit the culprit from selling the asset. He can also apply to have the account frozen. And under this particular point, applying to have the account frozen, in this particular bill, the financial institution must give information to the police and to the prosecution when requested to do so. And Section 56 says that hearsay evidence is allowed in relation to a restraining order. Now, I think it was Mr. Sands who made this point quite well, that if you are unable to prove that the individual's property was connected to the crime, if the prosecutor cannot prove that. For instance, if the individual, the culprit, if he is able to explain that this property was left to me by my grandmother, that this is what somebody left me on the will, and you can see, yes, that is how he inherited it, then, of course, the Crown is going to lose the case, and the person will have, and the Crown will have to pay that person some cost. So, yes, it was Mr. Sand who spoke on the whole question of due process. Also, of course, that you also have the power of appeal, like any other civil or criminal matter. You can appeal your conviction. And, of course, if you are successful, then that property obviously remains yours. It cannot be, you cannot confiscate it. And I think it was Senator Franklin who had a problem with this morning, that under the legislation, the AG's office, the Crown really, is the recovery authority. Now, I would believe that that is partly because this is not simply in the criminal domain where you would want the DPP or someone else to be doing that particular. I think this is more civil. It's a combination of both. And I believe that that is the reason why the AG's office is the office responsible in this case. Now, Mr. President, government does not have to give justification for how it deals with the funds after it derives money from confiscation and so on. Government doesn't have to give anybody any justification as to how it spends that money. In most states in America, what they do is that they use that money for stemming the flow of crime, and in particular, in their fight against drugs. So a lot of the money that they derive from this type of thing is used for a social good, to try to prevent the youth from falling into the same trap. So this money helps to fund things like literacy programs for at-risk children, similar to the children that we would have at government industrial school and so on. The money helps to fund children of that sort. A lot of rehab programs for young drug users. And it helps with things like rescue homes for people, for youngsters who are indeed, whose parents, for instance, have fallen into the trap and so on, and have left them without mother sometimes and without mother and father. So it is used to even support what would be the equivalent of our drug treatment court. That type of use is made of the money. And I believe that Barbados, in this particular piece of letter, that can use the proceeds that they derive from accounts and so on of these criminals for similar things. Because even if we can't make the rainfall, we can at least try and create a little soil with those children and so on, so that the rain can fall on them. So, Mr. President, I have full support I give my full support to the bill. And I finish simply by saying that as lawmakers, we must not be timid about making enemies. Can't be so timid, sir, that we neglect to carry out our obligations and our duties to this country, Barbados. Some people may not like us for the particular piece of legislation, but we do it because we think we have an obligation to this country to do it. I'm obliged, Mr. President.
Mr. President, I beg to move to a suspension of further debate on this bill today. No, you have to answer.
Question is that, further consideration of this bill, we now defer until a later occasion.
Mr. President, this brings us to the end of our business today.
All honourable members in favor, please say in favor.
I am going to I beg to move that this sitting be adjourned, sine die, with the understanding that the estimates debate is likely to be debated in this honorable chamber on the 25th, the 26th, and 27th, but members will be informed in due course.
The question is that this chamber be now adjourned until
Thank you.
before the day appointed, bearing in mind the indication that we are likely to be called upon for 3 days. To be meeting 3 days later in the month. But until that is explicit, the question is that we be adjourned sine die. All honorable members in favor, please say aye. Aye. Those against, please say no. And we now stand adjourned.